What is child marriage in America? Child marriage in America is the legal union in which at least one party is under the age of 18, permitted through statutory exceptions such as parental consent, judicial approval, pregnancy exceptions, or emancipation, even when the ordinary rule says marriage requires adulthood. In plain terms, it is a legal doorway that remains open for minors, and judges are often the ones holding the key. That is the clean definition. The shock begins when we realize how many jurisdictions still allow these exceptions, and how courts, applying those statutes, routinely authorize or recognize underage marriages. A quick origin story helps. Marriage law in the United States is primarily a creature of state statutes, not federal law. Historically, most states set a general floor at 18, but layered in exceptions that empowered parents and judges to consent on a minor's behalf. Over the past decade, advocates have pressed to abolish those carve-outs. Several states in the District of Columbia now ban all marriage under 18 with no exceptions. Yet as of the year 2025, child marriage remains legal in well over half of the states, and a small group of jurisdictions still have no absolute minimum age once exemptions apply. The result is a patchwork in which children can marry in one state and then carry that status across borders. Here is the headline detail many miss. As of early 2025, advocates report that 16 states have ended child marriage with no exceptions, while dozens still permit it through judicial or parental waivers. Meanwhile, at least 4 states, including California, Mississippi, New Mexico, and Oklahoma, lack a statutory minimum age once the parental and court approval pathway is used. That means, legally, a judge can still greenlight a marriage below any numbered threshold if the statutory process is satisfied. So why do courts uphold child marriage? Because statutes instruct them to. Many states require a minor and their parent or guardian to petition for permission. The family court then interviews the parties and decides whether to issue an order authorizing the license. California illustrates the mechanics. Minors need parental consent in a court order. Courts may require counseling and conduct interviews through family court services. Granting permission is expressly within the judge's discretion. Judges are not inventing this power. They are applying it. That is why, to survivors, the courtroom can feel like a rubber stamp, even when a judge is following the law as written. Another quiet reason courts appear to entrench child marriage is interstate recognition. Under the full faith and credit clause, states generally afford respect to each other's public acts and records, including marriage certificates, subject to some public policy exceptions. In practice, that often means an underage marriage validly celebrated in State A will be treated as valid when the couple moves to State B, even if State B would not have issued the license in the first place. The constitutional rule is about comity, not endorsement, which explains why the legality can follow the couple across state lines. Here is the most disturbing legal tangle. In many jurisdictions, marriage can negate or complicate age-based sex offense rules. Researchers have documented that numerous states either exempt sexual activity between spouses from certain statutory rape provisions or create defenses tied to marriage. Put bluntly, a minor who could not lawfully consent to sex outside marriage can, once married, be exposed to sexual activity that would otherwise be a crime, and the courtroom door may close to prosecution because of a marital exception. That is not conspiracy, it is code on the books. The why it is still legal answer, then, is structural. Legislatures have left parental and judicial exceptions in place. Judges administer those statutes. Constitutional comity pressures states to honor marriages performed elsewhere. And collateral doctrines, including marital exceptions in age-based sex offenses, reduce criminal exposure inside a marriage. When you stack those rules together, the system can feel rigged to preserve the possibility of child marriage even as public opinion shifts against it. Examples make this concrete. In a county family court, a minor appears with a parent. The court services unit conducts interviews, and a judge, tasked by statute with deciding best interests, issues an order allowing the license. Months later, if the couple moves, their new state typically treats the marriage as valid because it was valid where celebrated. If allegations of sexual abuse arise, Prosecutors may face narrower tools because some age-based offenses carry spousal carve-outs. Each step is lawful. Taken together, they sustain a system in which underage unions persist despite reform efforts. To be fair, the map is changing. In recent years, a growing roster of states, starting with Delaware and New Jersey, and extending through Pennsylvania, Minnesota, Rhode Island, New York, Massachusetts, Vermont, Connecticut, Michigan, Washington, Virginia, New Hampshire, Maine, Oregon, and Missouri, have enacted outright bans on marriage under 18. Advocacy groups have tracked these wins and continue to push in the holdout jurisdictions. Still, until every state closes its exceptions and sets a firm floor at 18, courts in many places will continue to approve or recognize underage marriages because the statutes tell them to. A curiosity to end. California, often perceived as the most progressive jurisdiction, remains among the states with no absolute minimum age once the parental and court approval route is used, hence the current push to enact a clean ban. This mismatch between a state's public image and its marriage code is part of why the topic keeps returning to the headlines. In the meantime, court websites calmly explain the underage marriage interview process, a reminder that the machinery is still humming. The ghost in the machine is not judicial indifference, it is statutory design. Above, I leave you more videos so you can keep learning law. Remember to leave us a like and subscribe.